Hi, Assalamualaikum. My name is Muhammad Zukri Azim bin Mahsan. So today our group, which is Muhammad Aris Daniel and Muhammad Nabil bin Risham. So today our group will present about thought of negligent occupiers liability for subject insurance liability for our Madam Nur Faiza binti Muhammad Sharin. So the article is from Mondak Kevin Wu and Associate Advocates and Solutions. Malaysia Thoughts of Negligence Occupiers Liability. The article date on 18 November 2022 by Kevin Wu and Zarul Farid. So the introduction. It's important to remember that determining fault would demand a true investigation by relevant authorities, attorneys or insurance firms to determine the exact cause and assign blame appropriately. They would evaluate the available facts, collect testimony from witnesses, and maybe consult lift mechanical experts. In mid-October 2022, two people were injured when a lift they were riding plunged down from the 8th floor to the ground floor of a condominium in Brickfields, Kuala Lumpur. Who is liable for this accident? Without specific, it is challenging to give a firm response since determining responsibility for an accident necessitates a complicated legal examination. I may, however, provide some general information on possible individuals who might be held responsible in such circumstances. The occupier responsibility legislation in Malaysia is founded on common law principles as there are no comparable statutes in place. Therefore, occupier culpability claims would fall under the negligent tort. So the principle of tort that are available in this case, the first one is property owner. If it can be demonstrated that the owner neglected to properly maintain or inspect the lift, or if there were known problems with the lift that were not immediately resolved, the owner of the condominium complex may be held liable.
So I'm a second presenter talking about principle of thought available. Number 2, management company. If a separate management company is in charge of overseeing the upkeep and operation of the condominium, they might be held accountable if they neglected to maintain the elevator correctly or assure its safety. So number 3, maintenance contractor. If it can be proven that a third-party contractor that we employ to service or maintain the lift was negligent in their obligation or neglected to address non-problem, they may be held liable. For number 4, manufacturer or installer. The business in charge of making or installing the lift may be held accountable if there is proof of a manufacturing flaw or improper installation. So this is a act related. Injury. Nicholas versus Mark's land cases. Act of God. The defendant was the owner of a series of artificial ornamental lakes which had existed for a great number of years and had never before 18 June 1872 caused any damage. On that day, however, after a much unusual fall of rain, the lake overflowed, the dams at their end gave way, and the water out of the lakes carried away the country brigades lower downstream. Had the injury found no negligence, the heavy rainstorm was a sufficient excuse as an act of God to escape liability under the rule in Raylands versus Fletcher. Act of God is the absence of negligence. The defendant could not have expected the extraordinary flood which caused her dam to break. No conduct of her was a proximate cause of the plenty's damage. So the next one, act related, practically of protection. Latimer versus AEC. flooding had occurred in a factory owned by the division following an unusual heavy spell of rain. This had left patch of the floor very slippery. Division had covered some of the wet areas with sawdust but had enough to cover all of them. The plaintiff employee was injured after slipping on an carriage area and sweat, alleging that dividend had not taken sufficient precaution in view of the danger. They should have closed the factory. The only way to eradicate the danger was to close the factory, but had that given the level of risk and the slippery patches were clearly visible, such a precaution to close factory would be improper.
So next, act related, damage and causation. Barnett v. Chelsea and Kensington Hospital Management Commit in 1968, a night watchman arrived early in the morning at the defendant's hospital, suffering from nausea, vomiting after having a cup of tea at work. The nurse on duty phoned the doctor, who refused to examine the man and advised that he should go home. The man died 5 hours later of arsenic poisoning. He had been murdered. The hospital commit was being sued for negligence, but the action failed. Held the failure of the doctor to examine the patient was not the cause of the death because it would not have been possible to save him. Thus, the commit is not liable. So we go to the next slide. So for the conclusion, a comprehensive investigation and study of the facts surrounding the occurrence are necessary to determine culpability in an accident like the one described, when an elevator plunges from the 8th floor to the ground floor, injuring 2 people. It is significant to highlight that assigning responsibility in such a situation necessitates a true investigation by pertinent authorities, legal experts, and specialists. To determine what caused the accident, they would gather evidence, evaluate the maintenance log, speak with witnesses, and analyze the lift condition. Liability will ultimately be decided based on the precise information learned during the inquiry. So, for court judgment, several variables including maintenance records, inspection reports, and any proof of carelessness and applicable rules and regulation must be taken into consideration to determine responsibility in a lift accident. It's crucial to remember that responsibility is often assessed on a case-by-case basis, taking into consideration the particular fact and supporting evidence that are brought forward in court. The only way to definitely identify who is responsibility in this particular situation is by a court decision or a legal expert reviewing the specific of the case. So that's all from us. Thank you.